I-751 denials and immigration court removal proceedings. Can a judge decide on my I-751 petition after it has been denied by USCIS? The answer is yes. The immigration judge has jurisdiction over denials of I-751 petition of removal of conditions of green card. So let's get right into it. How is it going to play out? Whether you file jointly or separately as a waiver, remember that we refer to a I-751 petition filed separately as a waiver. So whether you file jointly or separately as a waiver, the denial of that petition can be decided in court, because most of the time what happens is that USCIS will refer that case to court. So now that somebody finds themselves, in removal proceedings based on a denial of that I-751 petition, the burden of proof is on this government to prove to us that the marriage was not entered in good faith. They have to come with solid evidence, substantial evidence. The standard is very high. And on our side too, we have to come with evidence, factual evidence, to actually rebuttal their argument, because the standard is higher on them, but on our side too, the standard is higher too, because we have to be able to rebuttal their argument. But especially if they're accusing our client of fraud, oh my gosh, this is a whole other game. They have to have substantial and probative evidence. The standards are very high when it comes to fraudulent marriages, So that's how it's gonna play out, because when it comes to jointly filing, so it's mostly factual. But when it comes to separately filing, it's discretionary, It's up to the Attorney General to decide on whether or not to grant that waiver, right? So basically it's a discretionary measure when you file separately as a waiver and when the immigration judge is deciding in court, right? So this is the caveat here. Let's say that if the joint I-751 was denied by USCIS and the couple divorced before immigration proceedings started, you file jointly, then before you get your notice to appear, you have already divorced. How is this going to play out for you? Unfortunately, you have to go back to USCIS and file separately. And what's gonna happen is you're gonna ask the immigration court to continue your case until USCIS adjudicates on that newly filed petition. Because remember that the judge only has jurisdiction over a denial of a case from the start, If someone gets a divorce after they've already filed jointly and now they find themselves in removal proceedings, well, they have to refile separately as a waiver and ask the immigration judge or the court to continue their case until they get a resolution. And if they get a fair resolution with USCIS, then what's going to happen is they ask this case to be closed, to be closed so that they can adjust status with USCIS. As simple as that, but still complex, right? If you need a consultation, please call 202-751-2180. Email bijoux.ngwandaesq@gmail.com. Consultation fees apply. Until next time, bye-bye.